Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to murthy.com for contact information. From the beginning, Murthy.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The Murthy.com site provides you with latest and cutting-edge information on the US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is immigration updates. We will continue the knowledge session along with the last week's questions followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello, Ms. Murthy.
Hi, how are you doing today? Good to see you guys again.
Very well, thank you, and I hope you're doing well as well.
Wonderful, doing great. Weather is fabulous. Life is okay. Priority dates have moved. People are happy. Fall is here. COVID is reducing in the country. The United States is opening up to allow people from India to come next month, in a little over a month in November. So a lot of exciting, good, fun, fabulous things in the world of immigration, in the world of health, global health, and just the weather being very nice right now in the fall.
Looks like it's going to be a happy week. I mean, you seem all pumped up for the show, for the week, all set.
I'm always pumped up about life. Everybody who knows me knows my desire and my goal is always to think positively for clients, to figure out how we can fight and win cases, how we can, argue an issue, how we can think positively. Because if you visualize have you heard the famous saying, what your mind can conceive and believe it can achieve? So I always try to visualize success and victory for my clients, and I feel like that about life, and it's easy with nice weather, the COVID in the background, a little bit in the rear view mirror. I think in Maryland, the state of Maryland, I think almost 75-80% of the state is now vaccinated, and now they're releasing the booster shots. So everything is overall really good, and for immigrants also, a lot of movement in the priority dates, and we expect continued movement to, forward movement as well.
Right. So we have a caller on hold already, Ms. Gia from Michigan. Thank you for calling, Gia. You can ask Ms. Murthy your question directly.
Hi, Ms. Dorani. Hi, Ms. Sheela. Thank you for the support. We always admire for the service here. Ma'am, you're saying that the dates are paused to move, right? Are you expecting the filing dates to move for EP2?
So again, we share the information, as you know, Zia, based on what the U.S. Department of State releases the information, and what Mr. Charles Oppenheim, the chief of the Immigrant Visa and Control Unit at the U.S. Department of State, has explained that based on the huge number of unused immigrant visa numbers from the last year plus because of COVID-19 by the non-usage by U.S. consular posts around the world, we have a huge surplus of immigrant visa numbers that will be available. And when it's not used in the family-based quota, it rolls over and spills over into the employment-based quota. So yes, we do expect forward movement. Mr. Charles Oppenheim has explained both in the Department of State Visa Bulletin for October, for next month, October 2021, and in his monthly discussions with Charlie, that we can expect continued forward movement. EB2 should also move possibly more once more and more of the EB3 visa numbers are used by Indian nationals, particularly because of the downgrade applications that the adjustment of status applications that have been filed.
Thank you, ma'am.
Obviously, even he doesn't know, right? He doesn't know the world usage.
Right. Thank you, Ms. Murthy. So we have our next caller on hold, Mr. Praveen from North Carolina. Thank you for calling, Praveen. You may ask Ms. Murthy your question directly.
Yeah, hello, Ms. Murthy. Thank you. Thanks for your service in Sakshi TV. I have a simple question. On the 485 pending application, like for any reason, if we lose the job, like how much is the grace period to get another job?
So by law, there's really no requirement for a person to, nobody has really a grace period in and of itself by law, because remember, the green card is based on the concept of a future job offer. So as long as, if there is a loss of job, as long as the new employer is able to file a supplement J showing that the new job duties with the new employer are either same or very similar to the job duties as mentioned on the perm labor certification or the I-140 petition, then the case, the 485 adjustment of status should be able to get approved, even if the person has been, laid off or terminated or loss of job or quit or anything like that. So it really is not that important, because again, green card is based on a future job. So as long as in the future you agree to work with that same employer, or if it's a loss of job, file the supplement J showing new employer, and hence the new employer is taking the place of the old employer in agreeing to continue the sponsorship for the green card process.
Right.
Okay.
Ms. Murthy, we have a next caller waiting, Mr. Rakesh from Texas. Thank you for calling, Rakesh. You may ask Ms. Murthy your question directly.
I have a question. I went for the concurrent filing in last year, and my wife received EAD, green card EAD. Green card EAD. And simultaneously, we applied for the H4 and H4 EAD. We're still pending H4 and H4 EAD. So now she wants to use the AOS EAD for job purpose. So if she uses the AOA EAD, after that one, if she get a approval from H4 and H4 EAD, can she switch back without leaving the country?
Yes, there's no problem at all, Rakesh. So remember, the H1 and H4 are considered dual intent visas. You can have both non-immigrant and immigrant intentions. So you don't even need to. She can use the 485 EAD because she has an employment authorization document or EAD that allows her to work legally in the US. When the H4 gets approved, she can use that H4 EAD. A person can be on both H1 and H4 or H4 status, or 485 and the 485 concurrently or simultaneously. So you can have both H1 or H4 and 485 all together, and there's no conflict of interest. There's no problem, because the doctrine of dual intent allows a person on an H1 or L1 status only and their dependents on H4 or L2 to show that they have either immigrant or non-immigrant intent, and that does not conflict with the H1, H4, L1, L2 status. So she's allowed to extend the H4. You can extend your H1B even if she uses the 485 EAD, as I've explained before, Rakesh. So she has an EAD, use it, don't lose salary, don't lose income. She's allowed to go and continue working based on the EAD. She may need to provide that to the employer for I-9 purposes. And when the H4 comes, she can again show them the other H4 and say that I'm allowed to use either one of those EADs to continue working.
Right.
Good luck, Rakesh.
Ms. Murthy, so you were telling us about the immigration updates. So what are the updates this week?
So there's been nothing major based on what we discussed last week, Thorini. Basically, you have the adjustment of status cases that, of course, a lot of employers are trying to rush the September cases and get ready for the October filings, because there has been some forward movement in the priority dates to justify a lot more 485s being filed. Not as much as last year, October 2020, but still a decent number of cases. Also, yesterday on Monday, September 27th, of 2020, the Biden administration issued regulations, the Department of Homeland Security, on the deferred action for childhood arrivals, or DACA, for a lot of people who came as children into this country and for years and years were stuck because they can't go back to their home countries. They can't stay here because their status is not considered proper. I know it doesn't affect as many Indians or people of Indian nationality, but there are some Indians that are impacted, smaller percentage compared to other nationalities like South Americans or Mexicans. But still, there's enough children that are impacted. And this is a big deal because they were trying to do that to protect children who came years and years ago when they were very young and are dealing with a lot of complications in being able to study, stay, and work in the United States based on the DACA filings. And if those of you may remember that the Trump administration actually wanted to eliminate DACA and wanted to cancel it altogether, the Biden administration reinstituted it and has just introduced new regulations, a notice of proposed rulemaking, NPRM, as of yesterday, September the 27th of 2021. Thank you.
So we have a caller on hold, Mr. Shekhar from Boston. Thank you for calling, Shekhar. You may ask Ms. Murthy your question directly.
Yeah, sure. I have a slightly lengthier question. I try to make it short. See, my H1 got maxed out in the month of May, and I have applied for a B2. And in the last week, my 140 got approved, and my H1 also got approved with the I-94. So, however, when I try to check my son's status of B2 in the USCIS, we got received an RFP, and we did miss the deadline. 2 months got over. So what can be done to mitigate it?
Okay, so Shekhar, in a way, all extensions and deadlines for responding to RFE, in addition to the time that is mentioned on the RFE sheet itself, because of COVID-19, the USCIS has made special accommodations and given an extra 60 days grace period to respond to RFEs or NOIDs or motions to reopen, denials, et cetera, et cetera. So you might not have, the time may not have expired. Now, because you got the H1 extension along with the I-94 card attached, you could respond to that RFE simply restating that since the new change of status has been approved by the USCIS, we no longer require this bridge. The word bridge has to be within quotes, this bridge status that was only filed in order to provide bridge status while awaiting the H1B extension of status based on the I-140 approval. As long as you or your lawyer is clear on what to do and how to respond, the only reason I would do that is because the last thing you want is them to approve the B2 status, and then that becomes your last action of the USCIS, and potentially that could then be your status instead of your H1B approval. So you just want to make sure that you request the USCIS to withdraw that B2 extension that was only filed to be a stopgap measure / bridge application. Hope that's clear, Shekhar, and hopefully your lawyer is able to help you and guide you with that to make it less stressful so that you can rely on your H1B approval. Thank you.
Ms. Murthy, so my next question is, what usually happens after a person's visa is picked in the H1B lottery?
So if the person is selected in the H1B lottery, the USCIS can either approve the petition with the I-94 card attached, meaning change of status. So the person does not have to travel abroad to apply for a visa and then re-enter the US, or the USCIS can issue an RFE, a request for evidence, asking for more evidence about education, about experience, about job duties, being in a specialty occupation, the person's qualifications, credentials, proof that it's a specialty occupation, all of those usual things that we've seen RFEs on. Or in the worst case, they could issue a denial if they believe that the person is absolutely not qualified for the job, or the job that does not qualify for an H1 petition approval. So those are the three common issues. If you get an RFE, then obviously you have a certain period of time to reply. as I just explained, because of COVID-19, the USCIS has granted an additional 60 days extension on every case from the response date, an additional 60 days to respond because of shortage of staff and because of delays in processing and getting information because of COVID-19. So that's how we respond to it, and I hope that's helpful, Thorni.
Right, it was. So we have a caller on hold, Rakesh from Boston. So thank you for calling, Rakesh. You may ask Ms. Murthy your question directly.
Hi, ma'am. I have a question regarding interfering. I went for the downgrading in EP3 in last October, and my I-140 is not approved. So now in EB2, my date is current, and EB3 also current. So can I switch back to EB2 interfiling, and how long it will take? Is there any pros and cons for the interfiling?
So again, the processing time depends purely on the USCIS backlogs and processing cases, right, Rakesh? So all your employer attorney or your company attorney, whoever filed EB3, if they agree to it, just tell them to send back the EB2 approval and say, please interfile this previously approved EB2 petition for the beneficiary of the I-140 petition, Mr. Rakesh, since he wishes to pursue the EB2 job with the green card sponsoring employer, with the petitioning employer. And if the priority final action dates continue to remain current, if you have already provided your medicals and everything looks okay, and they decide not to call you for an interview, potentially they could approve it as long as the priority date in the final action date category is still current. If they don't approve it and the dates slide backwards or retrogress, then again, you have to wait for the dates, final action dates to become current, Rakesh, in order for the USCIS to be able to approve the I-485 for you and all of your derivative family members who are deriving the green card based on you being the principal I-485 applicant, because it's your perm and your I-140 petition that's approved. Thank you.
Right. Ms. Murthy, in regards to the previous topic that we were discussing, could you explain to our callers and viewers what an RFE is?
Yes, the RFE is the request for evidence, as I just explained. The USCIS generally gives about 87 days, a few days less than 3 months, to respond to most RFEs. During the prior administration of Trump, we often saw that there were trumped up excuses being made to issue RFEs without really good bona fide reasons. Almost every single H1B, even where the person was clearly qualified, highly educated, had multiple degrees, a master's degree from the United States, the USCIS would challenge the person's education, background, credentials, match with the job duties, etc. And as long as all of the criteria for an H1 are met and satisfied, the USCIS is supposed to approve the petition as required by the law and under its own regulations, except in the last 4 years, we saw multiple RFEs and denials on improper and flimsy grounds. And a lot of times when people filed appeals or sued the federal government, then they were winning the cases because the government knew they had a very weak case legally to issue the denials. So
Right.
that's really an RFE. You have 87 days, but now because of COVID-19, they're giving an extra 60 days of bonus period or grace period to process cases.
Right, so understood. But is there anything a person can do to perhaps reduce the chances of an RFE?
Well, like everything, if you do a much stronger filing, if you're between the employer and the attorney that the company hires or that you engage, make sure that you try to proactively address every issue in advance. And yes, that may mean a lot more time, effort, energy in making a very rock solid, strong petition to get an approval. But if that's what it takes, we always feel a stitch in time saves 9. And the more time you spend building a very rock solid foundation for a home, then the rest of the home will stay much stronger. Similarly, if you build a rock solid foundation with respect to an H1B petition by going through all of the legal and statutory and regulatory criteria, then it is a much higher chance of reducing an RFE and hopefully getting an outright approval. But even sometimes we have seen, even with a very strong case, some examiners or USCIS officers will purposefully make it very difficult and issue a lengthy RFE just to give somebody a hard time or for some weak, flimsy reasons. You have to then push back and fight back rather than thinking, oh, maybe there was a mistake. Maybe there was no mistake. Maybe there was a mistake, but maybe there was no mistake. Unless we look at the case, we're never sure what exactly might be the problem with the case.
Right. So, what are the chances of approval after an RFE, as in unless somebody files a lawsuit?
Oh, if you provide everything that they, to overcome the concerns or the questions of the USCIS officer or examiner, then hopefully there's more than a 90% or 99% chance of approval based on what are the issues, what is the person's background, what is the company's name and reputation, whether they have had issues or problems, etc. But in general, we find that when we respond forcefully, and you don't have to file a lawsuit, just do a very, very thorough and detailed and good job addressing the concerns. And if you believe that the USCIS is asking improper or illegal questions compared to what the law and statute and regulations require, then tell them that while providing them the information. And generally, we have had no problems in getting, I would say, an overwhelming majority of the cases approved through our fantastic team at the Murthy law firm.
Right. I completely believe that you are reputed after all for that. We have a caller on hold, Ms. Murthy, Mr. Noel from New Jersey. Thank you for calling, Mr. Noel. You may ask Ms. Murthy your question directly.
Hi, Ms. Murthy. I'm from New Jersey. I actually have a question about the maternity leave. So I am on H1B and currently my H1 is under processing. H1 extension is under processing. Our company offers the FMLA maternity leave. I wanted to know how many days leave can we take because we are on H1 and the FMLA is unpaid leave. And also currently I am in my firm processing, so I don't want to take any extra unnecessary leave if it affects the visa. Because if I get an RFE or anything, then I won't be able to provide the pay stubs because the company said they will not be paying us any compensation for maternity leave under FMLA.
Okay. Yeah, so we have dealt with this issue quite routinely, Noel. The USCIS, because it's obviously a federal government agency, has to respect and honor federal law like the FMLA or Family Medical Leave Act. And under FMLA, an employer, particularly if they're over a certain size, has to provide mandatory FMLA leave. It doesn't have to be paid. It can be unpaid, though there are possible changes that may happen in the law even with respect to that, Noel. But for right now, generally, most employers offer 6 weeks, some offer 12 weeks. Some even agree to keep the job offer open for longer. But you have to check what is the employer willing to do to keep the job offer for you, as well as what is the both federal and the state law requirements under the Family Medical Leave Act, under federal law and in the particular state that you are living and working, because those are factors that will be taken into account. So if the USCIS issues an RFE and asks for pay stubs, your employer can honestly respond saying, Noel was on an unpaid maternity leave as required under federal law, and we as the employer chose to provide this unpaid medical leave under the Family Medical Leave Act for the employee. However, the employee will return on this date, and at that point, we will be able to provide additional pay stubs or whatever. But it is absolutely permissible for an employee not to be paid and not to be working when the federal law allows and offers that as a benefit or a perk in order to protect the well-being and the health of both the mother and the child. Good luck, Noel. I hope you're successful.
Right. So, Ms. Murthy, My next question is, how long does it take to get a response post the biometrics?
So again, with biometrics, the real issue is what else is required. Just because you provide the biometrics, if it's for the EAD and AP, then it should be pretty quick, within a few weeks, couple months at most. But on the other hand, if it's biometrics and the priority dates have retrogressed so that the final action dates are no longer current, then even if you provided all the biometrics and your fingerprints, the USCIS cannot approve the 485 because the priority date is not current. And if it's not current for 6 months or 1 year or 2 years, they have to wait for that time. And as we all know, last October and November, literally tens of thousands of cases were filed. So the backlog is still there, and the USCIS has started approving the cases, but it's not thousands and thousands of cases at this time.
Right. So actually,
So
I have
that was helpful for me.
Right, it was. So, but actually, I have a question depending on what you just said. What is a green card quota backlog? If you could please explain it to our viewers.
So the green card quota backlog, that's the priority date.
Right.
So people who are born in a country like India or China, because there's something called worldwide quota. So every year in the United States, the US, the Immigration and Nationality Act under US immigration law allows for maximum 140,000 total employment-based immigrant visas each year. And that includes employment-based first preference for professors, researchers, scholars, CEOs of companies, and extra Nobel Prize winners, EB2 cases, EB3 cases, employment for professionals with master's degree, bachelor's degree, professionals, unskilled workers, special immigrants like religious workers, and employment-based fifth preference. So you have all these categories and there's a total quota, but no one category, no one country can get more than 7% of the worldwide quota of immigrant visa numbers each year. And because of that, a country with a high population, densely populated country like India or China tends to have a much longer waiting time, resulting in retrogression of priority dates, so that their green card for their nationals or citizens, instead of being approved immediately when they file the 485, they have to wait sometimes 3 years, 5 years, 10 years, 15 years to get the 485 approved because of priority date retrogression. And also when thousands and thousands of cases were filed, like last year in October of 2020, the USCIS is backed up with their processing. So that is compounding the problem and adding one more layer of reasons for continued delay in processing the cases.
I think you just answered my question. I mean, I'm sure you get this a lot about why are the USCIS processing times so long. I mean, I think that served as an answer for that. So with that, we come to the end of the show. Ms. Murthy, is there a golden immigration message perhaps that you'd like to give our viewers?
Thank you so much, Thorani. It's a great question to ask for a golden message. My attitude in life is we are dealt with a lot of the cards, right? Our parents are selected for us. Our country of citizenship or birthplace is selected for us. But the only thing in life we can change is our attitude and our mindset. And so if we think positive, feel positive, act positive, try to look at the positive, even in a negative situation when something isn't working out, then the negative will turn into positive in life, because what the mind can conceive and believe, it will achieve. And whenever life gives us lemons, if we can turn it into lemonade, we will be better off, we will be happier and healthier. Our family and loved ones around us will be in a happy state of mind because we are in a happy state of mind. And there's some things you just can't change in this world. So you might as well look at it positively. It will help you not just with your US immigration policy as a golden rule, but it will help you in your marriage, with your children, in life, with your parents, with your siblings, and keep you in good health. Thank you for this opportunity, and we look forward to continuing to help you and your viewers, Thorani. Take care. Bye-bye.
Bye-bye. I couldn't agree with you more, Ms. Murthy. Thank you. It was a privilege hosting you. You are watching Sakshi Live with me, Thorani Makana. Thank you.